Alright folks, buckle up. What we're seeing here is classic courtroom tension at its peak. The defendant is staring down the consequences of a felony charge, facing up to 10 years in prison, yet the judge is offering deferred probation. That's right, this could end with no formal conviction if he follows the rules. But here's the twist: one wrong move, one violation, and all that leniency evaporates instantly. Think about it. Would you risk probation or take your chances in a courtroom showdown? Stay tuned, because this case is about to reveal how the legal system balances mercy, accountability, and real consequences in real time.
Felony means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable for such a crime?
Yes, sir.
An agreement has been reached in your case, your particular case, where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. You would not be found guilty. And there would be terms and conditions of probation which are normal and customary, not only to this case, but also specifically to your circumstances.
Yes, sir.
Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
Here's the issue. This is all well and good, but if I place you on this probation, if you fail and you commit violations of your probation while you are on probation, you would come before me. I could revoke your probation and sentence you up to 10 years in prison then,
Yes, sir.
which you don't want. No, nobody would like that.
No, sir.
So it's going to be important that you understand fully what the conditions of probation are, and most importantly, you follow them.
Yes, sir.
And this will end fast enough because I can shorten probation for good behavior. Okay? And I do it all the time.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
So how do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty, and your attorney pleading, both of you pleading guilty voluntarily and because you are guilty? That's the guess.
Yes, sir.
Okay, I show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Understand it, discuss it with your
Yes.
attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection, admitted. Among other things, this states that you are mentally competent to enter your guilty plea. You are doing this freely and voluntarily.
Yes, sir.
You understand and appreciate the consequences of pleading guilty.
Yes, sir.
You have read the indictment, or it's been read to you. You were guilty of the crime charged and any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, it states down here, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived? All right, I'm a little unclear here. What do y'all want to do on the?
I believe that's what Mr. Dusler's looking for. Obviously, it's up to the court.
But it's.
I'm not opposed, but when you judge it, obviously, you're going to decide whether it's the 10 or not.
Don't know about this.
That's with the offense and with the challenges that he's made. And I'm not opposed to the 2 years, but if the court did allow for the 2 years, that he'd be on a mental health track there with probation, so he gets some assistance with.
If nothing further to add, I'm going to find you pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty.
Here, where things get really interesting, the judge isn't just handing down a standard probation. This is tailored specifically to the defendant's mental health needs, including medication compliance and monitoring. Notice how the judge emphasizes guidance rather than punishment, anger management programs, structured probation, and support services. This isn't just about locking someone up, it's a nuanced approach to rehabilitation, and yet the stakes are high. One slip, one missed session, one skipped medication, and the whole plan could be revoked. Audience, think about this. How much responsibility can a person handle under court supervision, and how effective is this system in truly preventing recidivism?
I'm going to place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation, which are normal and customary, but also suited for your particular circumstances and needs. You will be placed on the mental health caseload, and we will be monitoring to make sure that necessary medicines are taken,
Yes, sir.
and you will be required to take properly as prescribed all medications. There are a lot of conditions in probation here. There's 36, but when people look at that and they go, "My God, that's so many." Most of these are requirements I have to do.
Yes, sir.
Don't commit a crime.
Yes, sir.
Don't associate with bad people.
Yes, sir.
Uh,
I'm going to try not to.
support your dependents. See, all of those are things I mean, that shouldn't be punishment. That should be a guidance of good life, you know?
Yes, sir.
Now, there are other terms though that are going to be special for your particular needs. So make sure you follow them. And also you're going to complete what we call an anger management program, which helps people make decisions when they're under stress,
Yes, sir.
and pass that. Okay, please see the probation officer. Okay, thank you.
I don't think it's been very long. 2 months.
So, okay, I'm a little fuzzy about what you're saying, but what is it y'all want to, what's the end game? What do y'all want to do?
Well,
What is your goal?
he needs to understand that due to no fault of our own, he's been in prison for a good while. He would like to plead guilty for concurrent
For what?
time served on the new charge, evading
For evading
detention.
arrest or detention,
Evading detention with
which is, hold on,
it would be a misdemeanor, but for 2 priors makes it a sub-jail felony.
That's correct, Judge.
Which-
However, he doesn't have more than 2 months of credit on
and this
this
aggravated
case.
robbery in 03 doesn't affect
It doesn't
this
affect-
stage of felony
it doesn't affect
under
it
the
at all.
way it's indicted.
And he's got to get in a raw deal because he's been in prison a good while. Would like to get credit for all that, but since they didn't put the detainer on him until December the 12th of this year, he's only
Is
got
that
2
right?
months of credit.
Yes, Judge.
So, okay. Math, it's all math. How much is it? How long has he been in jail? How long have you been in custody?
I've been in custody 2.5 years, sir.
2.5 years. Okay, this is a state jail felony, my God.
It's a state
He
jail
can't,
felony.
he can't get more than 2 years.
Right. Well, we could do 180 days, but he's still got more time to do because he didn't get credit for this.
Yes, Judge, it's a system
What does it
error.
take for him to get out now?
Make it a misdemeanor.
Or-
Just going.
So even 100 days? He doesn't
He
have
doesn't
credit
have
for 100
his-
days?
He doesn't have
180 days?
No, he's got 2 months worth of it. He's got basically 60 days.
All
worth of it.
Verify that, please. I want to know how much time he's given credit for.
It. Oregon. And Lacey Grant talked to the sheriff's office and they didn't place the detainer until December.
December 12th.
Yeah, so.
We could do 1244B
Okay.
and just open it to misdemeanor.
Well, 44B misdemeanor at the time. Okay.
It's a state jail felony, but he's punished as though it were a class A misdemeanor,
Yes, instead of that.
which takes care of it, gets him out of here.
Yeah.
Okay, y'all work it out. Let me know when you're ready.
Okay.
If you want.
Let's see.
This is called 25 CL 1688 and 1689, the state of Texas versus Milton Richard. That's you?
Yes, yes.
Present with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in sum?
Yes, sir.
In summary, looks like each of these similarly allege that in 1688 on or about July 10th, 2025, and in 1689 on or about June 30th, 2025, in both in Jefferson County, Texas, you committed thefts. And because you have 2 or more prior theft convictions out of county courts of law or the criminal district court.
Now this is a prime example of the complexities of criminal math. The defendant has already served 2.5 years, but the legal machinery doesn't automatically credit that time due to how detainers and indictments are processed. Watch closely as the court navigates this tricky conversion from a state jail felony to essentially a class A misdemeanor for time served. It's not just about paperwork, it's about real lives and freedom. And here's the kicker: even when the law seems rigid, judges have discretion to make sure justice is fair. Audience, what would you do if you were in his shoes? Take the deal or risk the system's unpredictability?
And every time you steal a pack of gum, it's a state jail felony. And that's the way you don't want to steal, because it's something that would just be a little classy misdemeanor is now a felony every time, because that's the way laws are built because of criminal history as well as the circumstances of the crime. So you've got to quit stealing, or else it's always a felony. Do you understand what you're charged with?
Yes, sir.
These state jail felonies mean you face in each case no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment ranges for each cases? Okay. Each of these cases, the parties have agreed that you would be sentenced to 180 days in the state jail on each case to run concurrently. And looks like misdemeanor case would be dismissed.
Yes, sir.
Is that your understanding of the plan?
Yes.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes.
How do you plead in each of these cases? Guilty or not guilty? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will, and because you are guilty as these are. Yes.
Yes.
Okay. And then paragraph 2, which alleges these prior convictions in 2023 of County Court of Law 2 of Jefferson County, June 20th, 2024. That's a special day for me. June 20, by the way. County Court of Law 2, Jefferson County, Texas. And finally, February 24th, 2025 in this criminal district court. You were convicted of theft in each of those cases. Are those allegations true as they are alleged? And are you pleading true and correct to that voluntarily? And because it is true as it is alleged for those 3 prior convictions? Yes?
Yeah.
Okay. I'm going to show you what's marked as State's Exhibit 1. I'm going to ask you, did you sign the documents? Did you understand it? Discuss it with your attorney? Is everything true and correct there?
Yes.
State's Exhibit 1, tendered into evidence.
No, yes.
Without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, it states, so help you God.
Yes. Yes.
Correct. Yeah, you have to speak out so she can hear.
Yes, sir.
Yeah, or else the record is absent, and then we gotta fix it. All right, State's Exhibit 1 is made part of the record for all purposes, and it's admitted into this hearing in each of these 2 cases. Pre-sentence reports are waived.
Yes, sir.
I'm going to follow these agreements, Mr. Richard. I'm going to find in each of these cases you have pleaded guilty to state jail felonies of theft and true to these prior 3 theft convictions as alleged in paragraph 2 in each of the indictments. You are making your pleas voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases of these state jail felonies. I am following these agreements. You are hereby sentenced to confinement in the state jail for 180 days in each case. These are going to run concurrently. There will be, and this third case, which is, it looks like a trespass,
Yes, it's just.
will be dismissed as part of this agreement. Do you understand what has happened today? You're gonna be given credit for all time you have served, but the jail figures that up, not us. The jail does. If there's a problem, call him. I'll be close. The way, what's it showing? What's it showing his credit? This is unofficial, but we're always closer, just perfect on it. But she's showing,
I think.
Emmett,
Just 100, around 100.
she's just showing 100, but you know what it is. And the jail does. The jail does. Sometimes we don't get the data for us because that's not what our responsibility is for the jail. But if there's a problem, you let him know.
It's right at about 180. But again, the jail's gonna have to verify.
There are two cases and I'm having to duplicate to work on the second one to make all the papers work out.
In summary, today's courtroom session shows how probation, plea agreements, and judicial discretion intersect in real life. The defendant pleaded guilty to multiple state jail felonies, received concurrent 180-day sentences, and crucially was given credit for time already served. The judge structured probation to address not only punishment but rehabilitation, emphasizing compliance, medication, and behavioral guidance. This case highlights the careful balance the legal system tries to strike between accountability and second chances. If you found this case as shocking and insightful as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.